Good day, Internet. This is Chavez and Valko, the key to your immigration solutions. I am Senior Associate Benjamin Hamilton. As always, when you see me, we're here to talk about all things employment based immigration. And today we're going to talk about what we do when we have case delays or even case denials, right? This is obviously a big issue. USCIS and all the various agencies have always been the not the most efficient. But of course, that problem was compounded first by the Trump administration going out of their way and doing a very good job of gumming up the works. And then, of course, COVID hit on top of that. And now it's been very difficult to get basic things done. And what are your options in terms of, hey, my case has been stuck with USCIS, my case has been stuck with the Department of State, or maybe my case was even denied? What are my options? I'm going to be honest here and try to tell you straight out of the gate. There's really no magic bullet here, right? The agencies were difficult, to say the least, to communicate with to begin with. The Trump administration went out of their way to remove what little avenues of communication we had. Now the Biden administration has kind of sort of been bringing some of these back little by little, but yes, it is still extremely difficult to communicate with any of the agencies. It can obviously vary from place to place, but I think the number one thing that people want to talk about or want to hear about is USCIS case delays, right? Well, first off, if you call USCIS, who are you talking to, right? You're talking to somebody that works in a call center and really doesn't have access to much more than you do when you're like looking at your receipt notice and or your case history, right? If you're looking at my USCIS account, you'll probably find that the 1-800 number not terribly helpful. Now, where if you get lucky is if you can get them to escalate your case to a tier 2 officer, right? That means like an actual USCIS officer is going to look at the case and maybe then actually communicate with you. Now, one of the problems is that you get cases where you call, they upgrade it to a tier 2, but you don't quite know when that call back is going to come, right? In our case, more often than not, we have to like give out our cell phone numbers as attorneys because sometimes those calls can come like in the evening. Um, a week later, 2 weeks later, 3 weeks later, you kind of never know when it's going to happen. But okay, anyway, first, you got to try to cover all of your bases. Meaning, if you're going to go to one of the more extreme methods of trying to contact the agency, you have to have gone through all of the proper steps first, right? So, what are you going to do? Well, you're going to try to call and see what's going on. Hey, why is my case delayed? Was there an RFE? Are we missing anything? Are there any extenuating circumstances? Obviously, you can also try through Emma, which is the chat bot. Then you can go to the e-request, right? That's the case inquiry tool that USCIS has online. Like for stuff like, oh, I see that an RFE was sent, but I never got it, right? There's a couple of different things you can actually go to the case inquiry tool for. Obviously, it's for delayed cases. The case inquiry tool doesn't work unless the case is outside of processing time. And of course, who sets the processing time? Well, USCIS. So it's really easy for them to just be like, the average processing time on this thing's 2 years, right? And then, of course, you can't even send a case inquiry if it's still within processing time, which is kind of ridiculous, right? That they can set these insanely long case processing times, and that kind of, you know, resolves them of any sort of obligation to even like look at the case to see what's going on. But you still have to try to go through these proper steps to try and contact the agency kind of like the correct way, right? Just try to find out what's going on, right? Before you go to something more serious. Like, for example, you can look up something called the USCIS Ombudsman, right? It's an office that can help with case assistance, right? So you can go to the ombudsman if, hey, I've attempted to contact USCIS, haven't gotten anywhere, haven't gotten a substantive answer, then you can go to the ombudsman. Now, the problem is that the ombudsman is going to review the record, and if they don't see that you've really attempted any other way to communicate with USCIS first, a lot of times they'll just come back and say, sorry, we don't see any record of communication here. We can't help you until you communicate with USCIS. Like that can actually happen. So don't try to go straight to the ombudsman without first trying to call or do a case inquiry. So what are some of the stuff the ombudsman can help with, right? So you can Google it, USCIS ombudsman case assistance. There's actually a form that you can fill out online where you put in all your details, your case numbers. You can put an explanation of what happened, right? And you can submit it. So what are some of the stuff that they help with, right? For example, if you didn't receive a notice from USCIS, you didn't get a receipt notice, or maybe you saw there was an RFE issue, you never got the RFE, you called them, you sent your case status inquiry, nothing back from USCIS. Okay, now I'm going to go to the ombudsman because I need to get a copy of this RFE, right? Because if I don't respond, they're going to deny it. And the good thing here is that you can create that record. So if for some reason you don't get it and it gets denied, right, you can sort of appeal that denial and get them to reopen the case because you have the evidence that you didn't receive it and attempted to contact them, right? If you try to get them to reopen it and you have no evidence that you attempted to contact them, it's going to be a problem. They're not going to want to. If there's issues involving an age out, a child's going to age out, right? You can contact the ombudsman. If it's a military related case, family of a military member, cases that were improperly rejected. That is something we're seeing a lot more of lately. Like it's always happened, but I think we're seeing more of it. Like literally you're getting a case rejected and it's saying you sent the improper fee, right? And I'm looking at this notice that says improper fee, and I'm literally looking at the check that was submitted. There's stamps on it. I know this is the one they got. And I'm like, this is the correct amount. What is going on here? And you say, well, why would I want to contact the ombudsman's office? Well, what happens if I sent the case, the person's status expired, and then it gets rejected? So when I'm refiling, I'm now refiling technically late, right? That's one of those scenarios where you're like, well, maybe I'll contact the ombudsman, right, to sort of put that extra pressure on USCIS to accept my refiling, right? Because USCIS has the discretion to accept a late filing, right? They can do that. And so you want to put pressure on them to say, you need to accept this because the reason it wasn't being filed late is because of your mistake. Typographical errors in immigration documents. Again, you have to understand typographical errors is one of the things for a case assistance. So you got to send the case inquiry to USCIS first before you go to the ombudsman. Sort of lost files or file transfer problems between USCIS offices. So this could be where you filed your adjustment, it's been pending forever, but then you get a case transfer notice and then it continues to pen forever. That may be one of these ones where, maybe like it's still inside of processing time, but maybe I can actually do an ombudsman request because of that case transfer thing. Right? Cases involving an emergency or hardship. So let's say you made an emergency request on a work authorization or advanced parole, right? Obviously, the way you should do that is you call, you talk to the officer, you tell them what the need is, they escalate it to a tier 2. You would hope the tier 2 would then contact you to verify the information, right? But let's say the tier 2 just denies without even contacting you, then you could go to the ombudsman and say, no, this is a real emergency or real hardship, and they didn't even contact me. They didn't even give me the opportunity to present evidence regarding, maybe I have a sick family member that I need to visit, or a family member who's passed away. There can also be business related things like, oh, I need to go to this meeting to close this deal that's going to be worth a ton of money, and if I can't go, I'm going to lose the deal. Again, you have to first go through USCIS, and then again, a lot of times what happens is you call, make that inquiry, then it just gets rejected without them following up, and then you'd go to the ombudsman. Now, when it comes to, you used to be able to go to the ombudsman for case delays. Now they kind of backed away from that, right? So, for example, they want you to wait at least 30 days past the receipt date for case inquiry, right? So that's when you go to send your e-request to USCIS, right? It kind of shows when you can actually send that request, when they'll accept that request. And they want you to wait 30 days past that before you even go to the ombudsman. And basically, you have to have also sent the request, right? So basically, you send the request, wait 30 days, then go to the ombudsman. But they've kind of, in terms of priority, outside of processing times, they've kind of put at the bottom of their priority list, right? This is a fairly recent thing. It's because they're getting so many. Things they can't help with, obviously something that's within processing times. There's no processing time actually published. If you're seeking to change a decision, so basically if you're like, oh, they denied me and they're wrong. Well, ombudsman's not going to help with that, right? They're going to say file an appeal. If USCIS has like denied an expedite request, again, I think part of the argument there is to say they denied it, but they didn't actually deny it, but they didn't reach out to me before they denied it. I wasn't allowed to present information. Maybe go to the ombudsman. Anyway, so again, you first start with USCIS, then go to the ombudsman. Another option, obviously, is congressional inquiries. So if you go to any congressman or senator's website, there's usually like an assistance site, an agency assistance part of their website. So you can go there, click on USCIS. Sometimes you fill out a form online. Sometimes you have to like print a form and send it in. At the end of the day, what happens is the congressman's office can then contact the agency. Now, why is this useful? The congressman or the senator can't tell the agency what to do. They can't say approve this, right? It's more of the like, if I'm sending an e-request and an ombudsman and a congressman, right? If you're kind of hitting them from all angles, that incentivizes them to just get rid of this case, right? To just say, oh, wow, this person's like, we're getting all these different inquiries from all these different angles. Like, yo, Bob, this is your case. Bob, what's the holdup? Can you just get it out, right? The idea is kind of the death by a thousand cuts. If we're kind of hitting them from all sides, that may be the thing that pushes them to just get this case done, push it through, right? And you really want to make sure you hit all of your bases, right? Because sometimes, again, if you go to the ombudsman, they'll be like, well, have you done all these other things first? They kind of want to be, they want to be sort of your last resort choice. Obviously, this becomes a little bit more complicated when you start talking about other agencies, especially the Department of State, right? The Department of State, the Supreme Court has decided, this is longstanding precedent, that most of their decisions are not reviewable in court. You can't sue them in most cases. They know this, and so that gives them sort of unfettered authority to kind of do whatever the hell they want, right? But you can still, find email addresses for a lot of the consulates, right? A lot of times they have like a non-immigrant visa email and then a separate immigrant visa email, and so you can email them. Some of them have like a legal inquiry. Like I know, like the consulate in Juarez, right? They have a separate email for CDJ Legal, and they're like on their website. You can go and there's like you can actually submit an inquiry to the legal team through the website. Actually, the legal team doesn't want you to email it; they want you to do it through the website. And so it's more there about email, congressional inquiries. We're going to talk about something else there in just a second. But when it comes to how do I communicate with the agencies, look, it's not easy. There's no like really direct lines of communication. The one exception being, hey, if you're able to file something via premium processing, then great. There's an email address and there's a separate phone number, and you can get more direct contact, get in contact with an actual officer a lot quicker. They tend to respond within 24 to 48 hours. And they tend to actually provide substantive responses because, again, you're like more in direct communication with the actual officer and not just some call center. The one exception right now is the Texas Service Center, which we know for whatever reason is right now facing the most severe of all the staffing issues at USCIS, and is a bit of a mess across the board, even the premium processing unit. Another thing is like, why is everything taking so long? Why are there all these case delays? And again, it's 1,000 reasons. Reason number one, staffing shortages, right? USCIS is a fee-funded agency, right? So the more fees they get, the more people they can hire. They don't necessarily get a direct budget allocated to them from Congress, right? And so it's harder for them to staff up, right? Because it's kind of like they need to get the money first in order to staff up. And then if there's any dips in terms of receiving cases, that's less money, right? So, number one, staffing issues. A lot of it still has to do with everything is still paper, meaning you have to file a paper case that has to go through a mailroom, which is also having to be staffed largely by contractors. They must have a really high turnover rate over there because the mailroom is a complete, just utter nightmare. They tend to lose a lot of stuff. Like you get a request for evidence, it's like, we got your form, but you didn't send any supporting documents. And you're like, what? Like I have a scan here. Anyway. And then a lot also do work balance, right? So then if one service center gets overloaded, then someone has to package up a bunch of cases, physically mail them to another service center so that they can handle it. And then, of course, it has to be received at that service center. So it's really easy for things to get lost in the mail, get moved around. We also know, for example, right now there's a class action lawsuit involving naturalization cases. They seem to have found out that when COVID hit, a bunch of physical files were put into storage, which is like literally caves in a mountain, and then they've been unable to get them back. And so it's literally like USCIS doesn't have the case anymore. It's in storage and they can't get it. And so they're being sued. And I kind of wonder, I don't know this for a fact, but I'm kind of wondering if the same doesn't apply to that big group of Indian cases, right? Indian national cases, when there was a huge priority date jump in October of 2020, October, November, December, and there was a surge of cases, right? I mean, first off, it created all this demand that they weren't even able to, they didn't have the officers to actually adjudicate. And heck, they didn't have the mailroom staff to issue timely receipt notices. They were so overwhelmed. And kind of wondering if, because then there was some retrogression and there was a lot of downgrades and stuff. And I'm kind of wondering if a lot of those cases got ended up in storage and are just gone. I don't know. So what's my nuclear option on the case delays? What's my okay, I've done everything and nothing's moved. Well, it's called a mandamus. What is a mandamus? A mandamus is a federal lawsuit, right? You go to federal court and you sue the agency. And what a mandamus is that you're essentially suing them to take an action, right? Now, mandamuses, and a lot of times, can be effective. Now, the problem is this is not cheap, right? You got to hire an attorney who's authorized to, has experience and is authorized to file cases in a federal court. And you have to file this mandamus. Typically, when you file something with federal court, the U.S. attorney has 60 days to respond. Well, the U.S. attorney doesn't necessarily know a lot about immigration. It doesn't really want to deal with this kind of dumb case. So they kind of turn to the agency and they go, agency, what is going on? You need to do something, right? And so the U.S. attorney is kind of a little bit on your side in terms of they don't care whether the agency approves or denies the case, but they do want the agency to do something, right? Because if the agency does something, well, the U.S. attorney can kind of get the case off their plate, right? Oh, they filed this to compel them to act. They acted. So me, from a U.S. attorney standpoint, I'm done. I'm out, right? That's kind of what they want. Of course, what is the agency going to do? Well, you would hope it would be an approval, and that happens in a lot of cases where they just approve it. It's a case they've just been sitting on or lost or I don't know what, and they finally just approve it. Sometimes it can result in the issuance of a request for evidence, but hey, at least now the case is on someone's desk and they're looking at it. But that is kind of your nuclear option, is the mandamus. And we've seen mandamuses in, for USCIS, also for the Department of State, to try to get them to essentially act on a case. Now, let's say the agency refuses to act, right? Then you end up in litigation. Litigation is extremely expensive, and also you're never going to win when it comes to litigation unless you can show that you did everything else in your power before you filed the mandamus. So you don't want to just jump to that, right? Because if the agency doesn't act, and then you're like, okay, we're actually going to fight this out in court. I mean, the number one thing that the court's going to want to see is, well, what steps have you taken to date to communicate with the agency? And if the answer is zero, they're going to toss the mandamus case, right? So that's why you want to, go through, call them, keep a record of it, right? Of when you called, of what was, said in the discussion. If you get any notices, right, or any callbacks, case inquiry, when do you send it? Keep a copy. Ombudsman, keep a copy, so you have all of that, right? And obviously, when you file the mandamus, they include that information in the filing, right? They put all that. Hey, we contacted them. This. They put all that in there, right? And obviously, if you have a detailed chronology of everything you did in the actual original filing, then that puts more pressure on the agency to then do something. To actually act. So moving to the second point of, what do I do if my case is denied, right? Well, the most obvious option is to file an appeal, right? You're dealing with an administrative agency, so you file an administrative appeal. For most of our employment-based cases, those appeals would go to the Administrative Appeals office, the AAO. It is possible to file like a motion to reopen or a motion to reconsider directly with the agency. So like it's basically going back to the service center, right? Where you're saying, we want you to reconsider, we want you to reopen the case. And it's going back to the service center. Now, you obviously have a specific window in which to file this if you're going to file through the AAO. If you're filing back to the agency, you can sometimes get a reasonable time frame on the response. When I say reasonable, I'm like 6 months, 7 months, right? If it goes back to the agency, my experience is the agency more often than not is just going to uphold whatever they previously did, right? They don't want to, like, I guess, overrule what an officer did, and they tend to uphold it. So motion to reopen, motion to reconsider. Now, the appeal goes to the AAO. Now, the problem with the AAO is, A, they don't have any posted processing times, but in our experience, you're looking at over a year to get any type of response, over a year. And in most employment-based cases, right? I mean, I need this person to be here working now. I need to be working now. I don't have a year to wait. So we've come to find that over the last couple of years, filing anything with the AAO in most cases, not all, but most, it's a waste of time. Because you don't know, your odds of winning aren't necessarily the best, and it's going to take forever. And what do I do between now and then? So what do you do? What if you feel the denial is pretty egregious and you don't want to wait? Take them to federal court. So just like on the delay case, you can file a mandamus. You can file what's called an it's an appeal based on the Administrative Appeals Act, the APA. Basically, you sue the agency and you lay out why their decision was egregious, why it was unsupported by the facts, why it was unsupported by the law, right? And you go after and you sue the agency. Again, not cheap. You need the right attorney. Why do you do this? Well, just like on the mandamus, typically it goes to the U.S. attorney, who then has 60 days to respond. Again, U.S. attorney, they don't know a lot about immigration. I've had them tell me that directly. I don't really know if your claim is true or not because I don't know immigration law. And the fact of the matter is, they want to just get rid of this case. So what do? They go to the agency and they say, agency, do something. And what happens in most cases? Well, they reopen the case. In our experience, pretty much 100% of the time, they reopen the case within 60 days. They reopen it. Now, what do they do with that reopen? In some cases, they do reopen and approve. That happens. So you get a case denied, you file an APA appeal in federal court, they reopen and approve the case. Our experience is that in the majority of cases, or at least in a lot of the cases, they reopen and then they issue another RFE, right? They issue another request for evidence. Again, it's not ideal, but the whole point of this is, instead of waiting a year for an AAO appeal, I filed the federal APA appeal and got the case reopened in 60 days, got a new RFE, and now I have the opportunity to bolster my argument. Now, obviously, what you want to avoid is trying to include a bunch of new information, because they're just going to say, whoa. Yes, this information is all great, but it didn't exist at the time you originally filed. You can't just come in here with a whole bunch of new information, right? The whole idea is to go back and say, look, maybe here's some stuff that existed, we just didn't present, or you didn't ask about, or this is why your interpretation of this document is wrong, and you respond to that request for evidence. So these days, if someone gets denied on an employment-based case, let's say an H-1B, an L-1A, an O, we're far more likely to do one of two things. Just refile, right? Because again, the appeal is expensive and can take a year, again, if it's the AAO appeal, when if I just refile, right, I can select premium processing. So option one is just to refile, if that's a possibility. I would love to take USCIS to task, take them to court, because I know they're wrong and I could win. But from our client's perspective, they don't have the time or the money for that. Again, I would love to stick it to USCIS, and I know we could. But again, most cases, they don't have the time or the money. They just want this employee here. So obviously, option one on a lot of these cases on a denial, you just refile. But obviously, you have certain cases in which maybe they're already here, right? And if you refile, they'll be out of status. And so you don't have that possibility. Well, in those cases, we don't bother filing any type of appeal, and you can't refile. So take them to court, sue them in federal court. And more often than not, the case is going to get reopened. They're going to issue another RFE, and now you're back fighting with USCIS on that case. Now, when it comes to the Department of State, they have their own weird little thing. I mean, I guess you could try to file an APA appeal and get the case reopened, but they have their own thing called LegalNet. If you go to the Foreign Affairs Manual, you can Google LegalNet Foreign Affairs Manual and find there's a whole section on it. LegalNet is kind of like the AAO, right? The AAO is this like internal appeals body for like, USCIS. LegalNet is just like a internal appeals body for the Department of State. And the way you actually communicate with them, with USCIS, right? If I'm going to go to AAO, I got to pay a fee, which is like, it was like 600 something bucks now. And I got to file this form. With LegalNet, it's way more informal. There's no fee, and it's actually done via email. There's an email address. You go to the Foreign Affairs Manual. They have the email address there. It's legalnet@state.gov. They tell you how they want you to format the subject line and all of that of the email. They're very specific to go to LegalNet. What are the type of things that LegalNet will consider? Right? There's 4. Just read them to you. They're pretty straightforward. Legal questions about a specific case when the applicant or representative has attempted to contact post at least twice without receiving a final response, and where 30 days have passed since the second inquiry, right? Unless action is required sooner to avert significant harm to the applicant, right? So basically they're saying we'll consider delays as long as you've attempted to contact them twice, right? And waited an additional 30 days since the second inquiry, unless there's something really, really serious. And then you can kind of jump the gun and, this person's, I don't know, in a country where they're going to get killed or something if we don't address this. Where does this come up, right? We see like administrative processing, right? A lot of people get put in admin processing and they don't know why. Like some are pretty straightforward where it's like, I'm putting you in admin processing. Again, FYI, there's a difference between getting your visa denied and refused. I see a lot of people like, my visa was refused, and they freak out and they're like, they think they were denied and they're like, attorney, you screwed up. And it's like, no. Refusal usually means they're putting you in admin processing. So what can that be for? It can be a whole host of things. It could be maybe you have a criminal history they need to look into and verify, DUIs or arrests. It could be because of your nationality. Like, for example, Iranian nationals are going to get more inquiries about certain things like mandatory military service and whatnot. But the one we hate is the DS5535. This thing used to be rare. It happens all the time now. So they send you this list of questions, either in a form or an email, or they give you a piece of paper. And it's like 15 years of address history, 15 year of work history, 15 years of, all your social stuff. We want to know every single family member you have. It's like, and it used to be kind of rare, and used to be in cases like, you had Iranian nationals. We don't have an embassy there. And they were applying in another country like Turkey, and they would be the ones that get that form. And that made a little bit more sense. But now we're starting to see it happen all the time, all over the place, not a lot of rhyme or reason to it. And in most cases, it can throw you into a 6-month queue. Personally, I think what's happening is that info is being sent to an external source or person or entity or agency for review, maybe a contractor, and that whoever that contractor is just has this queue that's taking them forever, and it's kind of outside the embassy's hands. So if you're yelling at the embassy, why is this taking so long? The embassy's like, oh, and that's the case of a lot of admin processing stuff where the embassy is actually waiting on some other, like the FBI or the ATF or CIA. I don't know. They're waiting on another agency for information. But this is kind of one of your things to say, hey, if I have submitted, they gave me the DS5535 and I responded right away, and now months have gone by and I've emailed them, hey, do you need anything? What's going on? Right? Nothing. And again, and then maybe you could maybe go to LegalNet in that case and see if they'll help. Right? Obviously, you would also want to be able to like argue there's some type of need, right? We did one recently, not actually LegalNet, where we were actually emailing directly to the embassy saying, hey, this person has an O1. They've been in this admin processing now for months. And there's all of these people that are like waiting to utilize the services of this O1. And we were and they came back and they're like, okay, give us some evidence or proof about their like itinerary and kind of this back and forth with the embassy to finally get this to kind of push through. What else does LegalNet consider? This is the most common one. Questions about a specific case in which the applicant or representative has received a final response from post but believes it be wrong as a matter of law. So you can't really argue with them about like a factual interpretation, like oh, it's a certain fact. But if you believe they are wrong as a matter of law, you can go to the legal net. Now, the most biggest problem you obviously have is where if you're trying to go to legal net kind of comes back and says this was just the officer's, subjective decision based on the facts, right? And then legal net's just kind of like, nah, like this was a subjective or discretionary decision based on the facts. We're not going to overturn the decision. So you really have to be able to argue that they made a mistake of law. And we've seen that happen, right? I mean, they had a case where it was like an investor visa, and they're like, oh, we're denying you because you didn't provide evidence that you maintain a foreign residence. And we're like, what the hell? That's a tourist visa. That's an F1 visa. The Foreign Affairs Manual on investor visas actually says you don't have to maintain a foreign resident. It's in there. It's written. It's clear as day. You go back and you just say, well, we emailed the post and they ignored us. So now we go to LegalNet and say, this is a clear mistake of law. Now, one of the problems with the Department of State is since their decisions are non-reviewable, unlike USCIS that provides you a detailed denial notice, they often don't give you any like an actual reason. They just say 214B. What does 214B mean? It just means you don't qualify. So sometimes the frustrating part is you're trying to like go to LegalNet to say they made a mistake of law when like you don't know the actual decision. That's why it's 214B is BS, and I wish we could get rid of it and force the Department of State to, if you're going to deny someone, you have to give a reason. I don't care if it's one sentence, but you have to give a specific reason. Because then otherwise, how do you because they're like, we're denying this, but you're free to reapply. Well, how am I going to reapply if I don't know what changes I need to make or what I need to improve on if you're not telling me the reasons for my denial? So that's why sometimes we try to email with them, see if we can get some more info out of the embassy before we go to LegalNet so that we know really what it is that we're fighting against. They also will review questions about T visas, U visas, diversity visas, or adoption visas. And they will also look at legal questions revolving Child Status Protection Act. Kids aging out and stuff, and the Violence Against Women Act. Some things LegalNet will not consider. First off, they won't take questions from anyone who is not the actual applicant or their attorney of record, right? They will not review factual determinations, right, by the consular officers, including 214B denials on a tourist visa. So it's kind of like, unless there was something really, really, really egregious, LegalNet's basically not going to review tourist visa denials, especially if it's like a 214B. Don't go to LegalNet for case status updates. They will not entertain those. They also will not take general, speculative, or hypothetical questions. So if you're like, I want to apply, but is this going to be an issue? I'll go ask LegalNet. LegalNet's like, no, you don't have an actual case. So it's like courts in the United States. Courts won't take hypothetical questions, right? You actually have to have someone who, suffered a harm and has standing in order to bring the case. They also won't answer legal questions in which there's not a final decision. So like, I don't know, you have your interview, they send a request for additional information, then you try to go to LegalNet. It's like, well, no, there hasn't been a final decision yet, so LegalNet's going to intervene. Or like appointment rescheduling. If you want an explanation for like revocation or cancellation, right, they won't do that. You typically have to try to go to the embassy for that. So again, if you're dealing with the Department of State, you're really trying to communicate directly with the post, see if they have, like in Mexico, Ciudad Juarez, they actually have like a separate thing on their website where you can contact their legal department that's in the actual embassy. So it's like you're trying to contact the post, see if there's other means of communication to like a legal department within the post. Obviously, congressional inquiries, and then like you're going to LegalNet, and then potentially trying to go to federal court, like for a mandamus, if it's like a held up case, on like a DS 5535, like, oh, it's been pending 6 months, type thing, right? With USCIS, right? Again, you're like, oh, I'm going to call them. I'm going to do a case inquiry. I'm going to contact the ombudsman. I'm going to do congressional inquiries. And then I'm looking at filing a mandamus. And then obviously, in regards to denials, we're also looking at refiling the case or doing an APA appeal. With Department of State, you're usually looking at refiling the case or maybe going to LegalNet Again, it kind of varies in terms of what the egregiousness is, what's the basis of the denial. Again, the Department of State can be really, really hard because they don't have to justify their decisions, right? They just kind of, what was the decision based on? Well, you come in, they ask you 3 questions. They didn't look at any documentation. They made a decision. So it's like, what am I even fighting against? Like, it's insane. When it comes to like tourists and tourist visas and student visas, stuff like that. Anyway, look, there's no magic bullet here. There's no simple solution. There's no, haha, this will work, right? A lot of it comes down to money. And if you're willing to pay for something in federal court, like an APA appeal or a mandamus, to really kind of put pressure on the agency to move. Obviously, when you talk with an attorney, they're going to look at the specifics of your case and really determine, are you in a position to really file this or not? And then be real about like, what are the results? Like I said, our hope is just to get on the mandamus is just to get action, right? Either like an approval or a request for evidence, just action. And then on APA appeal, it's usually a case gets reopened. Again, we love it gets reopened and approved, but a lot of times it gets reopened and issue an RFE, but heck, at least it's reopened. And we can continue the good fight. As always, you can As always, you can reach out to us if you want to schedule a consultation to talk in specifics about your case. You can go to our website. Sorry, here, there may be a question, but I'm trying to figure out if it's a question that I know how to answer. Does emergency advance parole apply to people that have withholding of removal A10 status? Does emergency advance parole apply to people? I do not know the answer to that question. To be honest, I'm interested. Emergency advance parole. So, that have withholding of removal. So typically, withholding is someone who like would have applied for asylum, but they'd been here for more than a year, so they're not or they didn't file for asylum within a year, so they're only eligible for withholding, not asylum. And then you're talking about emergency advance parole. Well, when you apply for advance parole, right, you submit your I-131 to USCIS, and there's a difference between an expedite and an emergency. An expedite is we just want you to do this faster, right? And you do that usually by calling them. You talk to the officer on the phone, takes down the notes, escalates it to a tier 2 officer. And if it's accepted, right, it kind of like bumps your case up. So it can still take a month or more to get approved, but it kind of like bumps your case up in the list if you can get an expedite of an advanced parole, an I-131. An emergency is where you basically call them up and you say, I have an emergency. I need to travel ASAP, right? And we've seen this usually like with family-related emergencies. Typically what happens is when you make an emergency request, if they accept it, then what they do is they actually set you up for what's called like an InfoPass appointment at the local field office. So like, we have a local field office here in Dallas. And basically you go over to the local field office and you fill out a new I-131, bring all your supporting evidence, bring evidence of the emergency. You show up, you go to the window and you essentially present your application for advanced parole. And if everything checks out, they say, okay, we're going to approve this. Go sit down. And they go, whatever they got to do on the computer, and they will print out an approval, and you basically get it right there. But that's an emergency versus an expedite, right? And emergencies have to be, fairly dire circumstances. Like it can, and again, the other crazy thing though is I've seen, and we've had emergencies get approved, like for people that like a severely ill family member, maybe a death in the family. But I've also seen people have a death in the family and get denied. It's so kind of all over the place because it is a discretionary decision. You're having to get through that, make that phone call and get through that person at the call center, right? First. And again, a lot of it has to do with, well, what are the notes they're putting into the system? Maybe you're over here crying about like, this really close family member, like your grandma, who was the one who raised you, and they're about to die. And for all you know, in the notes, they're just putting like grandma sick, right? And that's what the tier 2 officer sees. And is like, nah, You're like, thanks, dude. So I mean, it's one of these things where you kind of have to be very specific in terms of the details. And I mean, I've literally like had them like read back, like, hey, so what are the notes you put down? What did you enter after I told you all of this? Right? Like, no, please like put this or add that or whatnot, right? Because what you're trying to do, again, on an emergency advance parole, is get them to schedule you for an InfoPass appointment at the local field office. So then you can go in person and usually come out with the advance parole that same day, is what you're really trying to do. Anyway, a lot of complicated cases, right? When you start talking about trying to get cases pushed through or appeals, right? Every case is unique. Every case is a little bit different. The exact strategy we choose is very case specific. So obviously go to our website. There you can schedule an appointment with any of our attorneys. Again, I manage our employment-based practice, but we have attorneys that do deportation, that do litigation, that do family. So there's someone here that can consult with you and answer any of your immigration-related questions. Hit us up on the socials if you have questions or comments. We're always open to suggestions for videos, right? And as always, what isn't complicated is downloading our app, Lawpilot Guardian, for Android or iOS, right? The base app is free, lots of useful information and tools there to stay abreast of all of the recent immigration updates. But hey, until then, I look forward to hearing any of your questions, comments, or suggestions, and we'll see you guys next time. And thanks for tuning in.